On November 6, 2021, Rakeem Mayers, artist known as ASAP Rocky, was involved in a heated argument near a Hollywood hotel. The encounter led to a criminal trial initiated by the state of California following allegations by Terrell Efron, a former associate, that Mr. Mayers committed assault with a semi-automatic firearm by brandishing a weapon and firing multiple shots that grazed his hand. On August 15, 2022, Mr. Mayers was formally indicted by a grand jury in Los Angeles, California. While the defense maintained that the interaction did not involve a real firearm and was instead a music video prop, the prosecution sought a conviction carrying a penalty of up to 24 years in state prison. On January 21, 2025, before the commencement of the trial, prosecutors offered a plea deal with a mandatory 6-month jail sentence, which Mr. Mayers rejected. On February 14, 2025, during the closing arguments, defense attorney Joe Tacopina argued that the state had willingly accepted the alleged perjury of their primary witness, Terrell Efron. Deputy District Attorney John Lewin fiercely objected to this outside the presence of the jury.
Do not mention the prosecution's verdict. Here's a quote. On an objection, you overrule. The prosecution accepts their witness committing perjury. It's improper, it's unethical, you said you're not going to tolerate it, and I object, and you make it clear to the jury that my objection you find annoying. It's very clear that the tone that we get when we make an objection that should be sustained is, what are you doing? That's what was said. You specifically...
Lower your voice and don't yell at me. I told you before. I'll listen to what you say. Speak in a normal tone of voice.
Judge, we're doing the best we can to make sure that this trial is ethically conducted. They have repeated, I've objected, you told them it's improper. You overruled repeated objections where they are saying improper things. He just said a moment ago, this is a direct quote, the prosecution accepts their witness committing perjury. I object. You respond, that's appropriate comment on the evidence. It is not appropriate comment on the evidence, Your Honor. I don't know if you didn't hear it.
I didn't hear that.
So, Judge,
what I heard, I could have been wrong. What I heard was that Mr. Tacopina was describing Relly as committing perjury.
Judge, that's a direct quote. The direct quote was, the prosecution accepts their witness committing perjury. Here's another one. Relly committed extortion. There is no legal...
Do you think the jury's going to ask for what the legal description of extortion is?
Your Honor.
Forcing someone to pay money, that is, quote, extortion.
No, Your Honor.
Go on to something else.
Your Honor, I want to make my record. I mean, you're going to do what you're going to do, but I have a right to make my record. No lawyer can get up here, no lawyer can get up here and tell the jury that a crime has been committed when there is no instruction on that crime. When in fact, Your Honor, that's not the legal definition of extortion. We've objected, and the court again is basically telling me, don't worry about it, it doesn't matter. Your Honor, it does matter. After a while, when there are so many of these things, they add up. And when the court is saying, wow, what they don't care about it.
No, I didn't say they don't care about it.
It seems, Your Honor, it's improper argument. And the problem is...
I don't agree with you. I think using the word, quote, extortion to describe the conduct is not improper. I think it's fair comment on the evidence. You, in your rebuttal argument, you can say it wasn't extortion. You can address it.
Mr. Lewin argued to Judge Arnold that Mr. Tacopina engaged in defense misconduct during closing arguments, violating the constitutional boundaries established under People v. Hill by improperly asserting to the jury that the prosecution allowed their witness to commit perjury. Under the precedent established in People v. Wharton, California law permits trial attorneys broad discretion during closing arguments to analyze the facts and formulate reasonable deductions based on the admitted evidence. Under People v. Hill, trial counsel are strictly prohibited from presenting facts outside the admitted evidence, just as they are barred from asserting personal knowledge of uncharged offenses under Rule 3.4 of the California Rules of Professional Conduct, or alleging that opposing counsel suborned perjury without foundational support in the record. Even when a contemporaneous objection is raised during closing statements, the trial judge retains sole discretion over whether to sustain the objection or to categorize the remarks as permissible zealous advocacy. Furthermore, under the landmark framework of People v. Green, counsel must explicitly request a curative admonition to the jury to fully preserve the issue for subsequent appellate review. If an attorney does not interpose a timely and specific objection and request an admonition as mandated by Evidence Code Section 353, the claim of misconduct is legally forfeited and the issue cannot be raised on appeal as a basis to overturn a verdict. Here, Mr. Lewin objected to the defense's characterization of Mr. Efron's testimony, contending that the defense was extrapolating an improper inference that lacked a foundation in the trial record regarding both the witness's credibility and the prosecution's ethical conduct. Mr. Lewin further objected to the defense, alleging to the jury that Terrell Efron committed extortion, but Judge Arnold overruled the objection, ruling that the terminology constituted a permissible inference from the evidence, which could instead be addressed during the state's upcoming rebuttal argument.
The bigger issue, as I said, is the court repeatedly told them, do not connect the prosecution to committing perjury.
I'll tell you what, I didn't hear that. I'm going to ask Kathy for the exact quote. If that's what was said, I'm going to sustain your objection, and I will apologize for overruling.
Judge, can I respond, please, on that one issue? Not everything else you said. What I said was, and I agree with what I said, but understand the context of it, okay? I didn't say this is more perfect. I didn't say it yesterday, I didn't say it today. But one thing I said, and it was very common, was the prosecution accepts their witness committing perjury. And what I mean by that is in regards to one thing, and it's indisputable, Your Honor. It was regarding Relly saying the tape was fake. The tape was fake. They got up, cross-examined Mr. Sajemi, did not ask him if the tape was fake or not. Okay? They then put up transcripts of that tape recording with attributions to Mr. Efron. So that means by that, just by that very fact, they accept the fact that he committed perjury. I'm not saying they support it, but they accept that that witness committed perjury. They have to. Let me finish. There's no other way for them to move forward unless they say that wasn't perjury, but it was because he said that was fake. We know that wasn't fake. It was real. That was perjury. So by then moving forward with it, arguing that that tape is important for the prosecution, that Efron said these things, that when they cross-examined Sajemi, that wasn't being a good friend to Efron because he made a tape. All that is doing is, I'd say this is warning. It's different. I would never say that. I didn't say it yesterday. What it is doing is accepting it because they didn't say, you know, we have an issue with this witness. He's committed perjury. It's accept. I said they accepted their witnesses committing perjury. That witness committing perjury on that one issue. That's fair comment, Your Honor. It's not inappropriate. It wasn't disparaging counsel. I didn't say Mr. Lewin. I just said they accepted, and that is true. That there's no other way around it.
Judge Arnold clarified that if the defense asserted the prosecution knowingly suborned perjury, he would sustain the objection. Under California Criminal Procedure and Penal Code Section 127, an attorney is strictly prohibited from accusing opposing counsel of subornation of perjury absent an explicit evidentiary foundation in the trial record. Mr. Tacopina countered, outlining a timeline where the prosecution's star witness, Terrell Efron, had previously testified that a critical audio recording was fabricated. Mr. Tacopina highlighted that the prosecution subsequently failed to address this claim during their questioning, yet later introduced written transcripts of that exact recording into evidence, explicitly attributing the dialogue to Mr. Efron. Mr. Tacopina argued that by treating the recording as authentic through the introduction of transcripts, the prosecution logically accepted the fact that Mr. Efron's prior testimony was false and created a material conflict in the state's case. Mr. Tacopina further asserted that his line of reasoning constituted a protected, fair comment on the evidence rather than an impermissible personal attack on opposing counsel. While an advocate cannot accuse the state of actively orchestrating or collaborating in false testimony, which would violate California Rules of Professional Conduct, Rule 3.4, they may argue that the state's own evidence undermines its witness. Under California Evidence Code Section 780, the jury is ultimately empowered to weigh any contradictions within a witness's statements and the consistency of the evidence to determine their overall truthfulness and credibility.
It is not fair comment. It is completely unethical.
I agree with you.
So, Your Honor,
I agree with you.
What's frightening is Mr. Tacopina just stood up here and basically defended, said, yeah, I said it, but I can say it. He doesn't know or care about the law. That is clear. And Your Honor, when it's happened 25 times in this trial, with the hiding of evidence, with the late discovery, and with repeated, you told counsel before we started, do not disparage the other side. I said yesterday, you argue what you want about witnesses. You say a witness lied. You do not disparage counsel. You repeated it yesterday. He tried to explain how he didn't make mistakes yesterday, which he did. Now he gets up and he's now admitted, yes, I made that comment, here's why it's appropriate. Your Honor, it's not appropriate. It's completely unethical. It is immoral, and it's not professional. And again, Your Honor, the fact that he is getting up here saying, yeah, I said it, here's why, just demonstrates again, he doesn't know the law or doesn't care.
You're disparaging him right now.
I'm disparaging him because, Your Honor, he's not following the
There
rules
is not to be any disparaging of either side.
During argument, the jury's not here. I have every right, obligation, and duty to stand up here and point out when he was being unethical. The first time the court catches me being unethical, Your Honor, the court knows. That'll be the first time. Court knows I don't do that.
Oh,
Court knows. Court's already made.
I've heard enough from both of you. I missed the prosecution accepts their witness committing perjury. I don't think that's fair comment on the evidence. I think that's an improper statement. It infers that the prosecution is allowing perjury to occur. I'm going to sustain your objection, and I'm going to apologize for overruling it, and then move on. If I were the two of you, I would just move on and not make bring it to the jury's attention. I would point out, though, I told you at the beginning of arguments that if an objection is made, I'm going to do my best to call it as I see it. You have made 17 objections. I have overruled 12. I have sustained 5. I'm doing the best I can. I will continue to do the best I can, and that's all I can say.
I just want to put on the record that, these remarks about being unethical is not just about had it with him. This from a lawyer who, and I was staying yesterday on it, this from a lawyer who asked in front of a jury for a stipulation that a shooting range was not in California when either he knew it was in California or had no idea that it was in California. Okay? So he literally asked for a stipulation in front of a jury that he knew was not true or didn't know if it was true. And that's unethical. That's unethical. And this is a guy who, the Ninth Circuit just said lied to a jury in the Branford case.
Your Honor,
so
Your
I
Honor,
want to hear about him.
one more thing out of him, and we air everything that's happened in this case, which the court's aware of.
Stop.
He might want to stop.
I'm so threatened.
You should be, Joe.
Oh,
Let's take a break.
You should be.
don't tell the courts ever told me I was a liar.
Hey!
Oh, yeah. I'm so scared of you.
Stop it!
Mr. Lewin argued that Mr. Tacopina's closing remarks exceeded the traditional latitude granted under the fair comment doctrine, characterizing the defense's assertions as a severe breach of the California rules of professional conduct. Under People v. Hill, there is a clear line between questioning a witness and accusing a prosecutor of breaking the law. Furthermore, Judge Arnold validated the prosecution's position, ruling that the defense had introduced an improper statement regarding the state's trial tactics. To maintain the integrity of the proceedings pursuant to his judicial mandate under California Penal Code, Section 1044, judicial finding must distinguish between a witness's independent testimony and the state's intentional subornation of perjury. Judge Arnold sustained the objection, ruling that the defense's narrative lacked the requisite factual foundation. However, Mr. Tacopina challenged Mr. Lewin's historical adherence to the duty of candor toward the tribunal under California Rules of Professional Conduct, Rule 3.3. He cited a prior instance where the prosecutor allegedly induced a jury to accept a false stipulation regarding the location of a California shooting range, thereby arguing that the state's own history of judicial censure disqualified it from asserting procedural and ethical superiority. After that, Judge Arnold declared a break. On February 18, 2025, Mr. Mayers was acquitted of all criminal charges following a unanimous jury verdict that absolved him of any prison sentence. This case illustrates the critical importance of procedural boundaries in criminal proceedings and the judiciary's role in managing high-intensity courtroom conflicts. Judge Arnold's intervention during the discussion between Mr. Tacopina and Mr. Lewin ensured that the trial could proceed under the strict guidelines of legal ethics rather than uncontrolled rhetoric. By carefully evaluating the specific objections raised by the prosecutor regarding Mr. Tacopina's summation, the court reinforced a fundamental principle of trial practice, that an advocate's right to zealously represent their client does not extend to groundlessly impugning the integrity of opposing counsel. While the court determined that Mr. Tacopina's characterization of witness conduct as extortion was a permissible inference from the evidence, it correctly recognized that the defense's assertion that the prosecution accepts perjury unacceptably crossed into prejudicial misconduct. This outcome underscores the vital function of judicial oversight in safeguarding both parties against structural unfairness and maintaining the integrity of the criminal justice system when faced with high-profile adversarial allegations. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.